having Katie Wright and David Ryman to talk about the lawsuit. The discussion topic is extreme gender gerrymandering in Utah, the lawsuit. So thank you both for being here. You take up the time, however you want to.
And I just lost, I don't know if anyone else can see it, but I just lost the presentation, Katie.
You can't see the presentation?
No.
Okay, sorry about that. Let me try again.
There we go.
Okay, great.
So I know some of you on this call, Linda and I have been working on another case that you guys are involved in as well. So it's good to see you. For those of you who don't know, I'm David Ryman. I'm at the Parr Brown firm, and I've been one of the lawyers representing the plaintiffs in the redistricting case, along with the Campaign Legal Center, which is a nonprofit out of Washington, D.C. that specializes in election litigation, and with the Zimmerman Brewer firm here in Salt Lake, which specializes in appeals. And so we are now up on appeal, as I'll get into. And so we kind of assembled the team with the idea that that we would have someone for every stage of this case. So that's at least who I am. We filed this lawsuit. It's been almost a year ago now. It was last spring, and we brought it on behalf of your organization, the League of Women Voters of Utah, and also Mormon Women for Ethical Government as organizations who have members that are impacted by what the legislature did, but also on behalf of individual plaintiffs. And among the list, we have someone that's in every one of the 4 congressional districts that were split. And I can't remember who it is, but one of our plaintiffs can walk from all 4 congressional districts in about 15 minutes from her house because it's just split right down the middle. And so all of those people are the plaintiffs that are suing, on behalf of injuries that they have sustained by dilution of their votes, but they're really kind of standing in as surrogates for all the voters in Utah whose voices have been diminished as a result of what the legislature did. Let me just move this so I can make sure I can see. There are the lawsuit challenges the congressional maps and just the federal congressional maps, and that's not because Utah's state maps are good either, but this is all sort of uncharted ground legally, and at least in Utah state constitution. These cases were decided in federal courts until about 5 years ago, and when the Supreme Court ruled that federal courts were no longer going to adjudicate partisan gerrymandering. And so what we are hoping to do in this lawsuit is to establish legal principles that can be applied not just to the congressional maps, but also to state maps. But this lawsuit just focuses on the congressional maps, and it raises constitutional challenges to them. And just very briefly, the provisions that we're relying on, the claims we've brought, rely on specific provisions of Utah's constitution, most of which are either different or don't have an analog in the federal constitution. And the first one is the latter, the free elections clause. There's no similar provision in the federal constitution, and the provision ensures that Utah's elections shall be free, and states that have similar language going back to reasons that date back to English common law have held that doesn't just mean there's no poll tax. It means that your vote in an election has to have substantially equal voting power to other people, and that by diluting voters' votes, you're essentially rendering our elections not free. And the other provisions we're relying on. The first one, equal protection there that you see there, it's actually under Utah's constitution called the Uniform Operation of Laws Clause, but it operates in somewhat similar fashion to the federal provision. There are some differences, but essentially the idea is that the gerrymandered maps treat people differently based on their past political preferences. The freedom of association and freedom of speech are rights that you probably are more familiar with in the context of the First Amendment, but they are implicated here because voting is protected political speech. And the gerrymandered maps not only make it difficult, if not impossible, for like-minded voters in communities of interest to associate for the purposes of choosing someone to represent their common interests. But it also retaliates against people for their past political speech, their past voting patterns, which is the data that they use to draw maps to ensure that people who have voted, usually in this state, for the Democratic Party or not a Republican candidate in the past, won't have their voices heard as much. And then the last one is an affirmative right to vote. There's another provision in Utah's Constitution that there's no analog to in the federal Constitution. There's no actual right to vote in the United States Constitution. It's just sort of seen as implicit from other rights, and that was kind of advisedly by design, because as you can probably recall from at least history class, not everyone had the right to vote when this country was founded. And so our argument here is that the right to vote is diminished when your vote becomes functionally meaningless. So that's kind of the constitutional challenge to the substantive maps. And then the second sort of kind of aspect of the case, and I'll be very brief here, is that Proposition 4, which many of you I'm sure are aware of, that passed in Utah and established the Independent Redistricting Commission that the legislature then immediately repealed. We argue that because the power to reform government is a sovereign power that's granted by Utah's Constitution to its people, that all legislative power derives from the people, not from the Congress or from the legislature, that the legislature's repeal of Proposition 4 was unconstitutional as well. And I've already mentioned the legal team, so I think we can skip over this one, Katie. So here's let me just give you a brief update as to where the case is. And I'm not sure what the next slide says, but I'll just cover where we are, Katie, from where we were. We filed the case in the spring. There was a lengthy period where the legislature tried to get the case dismissed on a number of grounds, but the main argument was that the courts have no role to play at all in adjudicating whether the maps that the legislature drew were unconstitutional. They essentially say, well, we could concede that they violate the Constitution, but the court can't get into that because it's just a political power that we have and we're unchecked by any other branch of government. They tried several times to get the case stayed, which were unsuccessful until and the court eventually, the trial court, this is Diana Gibson on the left. She's the judge in the case. She's an excellent judge, and denied the legislature's attempt to get the case thrown out. And when she did that, the legislature sought what's called interlocutory review by the Utah Supreme Court, which is discretionary. They don't have to take that, but they did. In this case, they agreed to review it at this stage of the case. And we don't know what that means necessarily. It may mean nothing, it may mean something, but it's hard to read tea leaves in that situation. But that's where the case currently is. It's at the Utah Supreme Court, which is reviewing Judge Gibson's decision not to throw the case out. And so that is what it says here, interlocutory appeals granted January 7th. And because they granted review, the district court said, well, because they're going to review it, it doesn't make sense for us to go forward with other proceedings in the trial court. And so the trial date that we had originally scheduled for May was vacated, and we're now just in briefing before the Utah Supreme Court. And they've set oral argument, as it says down here, for July 11th to hear oral argument on the matter. So we're in the process of briefing that for them. That's basically where the case is. And with that, I just wanted to mention one other thing that you may have questions about, and then I'm happy to turn it over to you all for specific questions. But you may be aware of a case that's at the U.S. Supreme Court that you might have seen in the news called Moore versus Harper. That is a case that has already been argued at the United States Supreme Court, and it's a case out of North Carolina. Where the North Carolina Supreme Court did something very similar to what we're asking the court do here, which is to hold that maps that were gerrymandered in that state violated provisions of the North Carolina Constitution, and including a similar free elections clause that they have there. And they issued a very, very long, very well-reasoned opinion that is sort of a model for if the court wants to do what we're asking them to do here to do that. Ordinarily, when cases are decided just on state law grounds, the U.S. Supreme Court doesn't have any role in adjudicating that. They can take appeals from state Supreme Courts, but only if they involve a federal issue, federal question. Usually, state Supreme Courts are the final arbiters of what their Constitution means. There are some very rare circumstances that don't really apply here to that. But in this case, and I just want to put this on your radar screen because the decision will probably be coming out sometime in the next few months, June at the latest. The North Carolina legislature is arguing that there's a provision in the federal Constitution that says state legislatures have the obligation to determine the time, place, and manner of congressional elections in their state. Their argument is that that provision means that only the legislature can determine how lines are drawn, and that the state courts have no power to review it. It's kind of a radical theory that has never been endorsed by the U.S. Supreme Court, and as far as we're not in any robust way by any lower court. But it is the question on which they granted certiorari, which means there were at least 4 of the justices that wanted to at least decide the issue. They heard lengthy oral arguments earlier this year, or actually late last year, I believe it was. And if the case comes out as the North Carolina legislature wants it to come out, and I think this is unlikely, it may end up somewhere in the middle, it would effectively gut any protections that all states have in their state courts to enforce their constitution against the legislature. So there's a very, very dangerous potential decision that's coming out later this year. So I'd advise anyone who's interested in these issues to at least keep an eye on that one issue that's outside of Utah, because it could have an effect here, not just here, but everywhere in our country. And with that, that's about all I plan to say, without questions. So I'll just open it up to see if there are any questions that anyone has before we move on. Because I have to, like I mentioned, some of you weren't on, but I have to jump off at 11:30.
David, can you say again what on July 12th the Utah Supreme Court is going to decide? That's still not clear to me.
Yeah, so I think it was July 11th.
11th, okay.
And what happens on an appeal is that there's a period of time where we draft and submit briefs. So they're the appellant. So they'll submit a brief probably in the next month or so. And we will get a chance to respond, and they will get a reply brief. And that whole process will probably take us into early June. And then the court will hear arguments. So they convene the full court, and we will go down there. We'll present oral arguments. They'll be able to ask questions that usually lasts, depending on how interested they are, about an hour. And then they will have some period of time after that to issue a ruling. Sometimes it can take quite a while. Sometimes they can act quickly, but usually it's a matter of a few months at least before they issue an opinion. And sometimes they move more quickly in election cases, and we've emphasized to them the urgency of trying to get this done before the next election cycle, which would require it to be effectively resolved by the end of this year. But they're not moving with alacrity so far. So on July 11th, we won't know how the case is going to come out. We'll have some indication about how the arguments go, but I would expect we won't really know what's going to happen until probably the fall.
So they're just saying that it's going to be heard and they're going to go through the process, but they're not deciding anything then.
That's right. They very rarely will issue a decision before they hear arguments. And I've only had it happen once in my career, and it was another election law case, but there was a massive amount of urgency. And so they sometimes will issue what their decision will be. And then they'll say opinion will follow, but they go through a lengthy opinion writing process where drafts get passed back and forth in their chambers, just like the U.S. Supreme Court does. And so that takes a while.
Okay. All right. Other questions or comments? There are quite a few people on here, so I can't see everybody at once.
Oh, please repeat. Sorry, I just pulled up. Someone else already answered the question about Diana Gibson. Yeah, she's here in the 3rd District in Salt Lake.
Okay, in the chat, you mean?
Yeah, sorry, I just pulled up a question, but someone else already answered it.
Okay, well,
I
Linda,
think,
Linda Smith, go ahead.
Could you please repeat what the legal issue is before the court? What's being appealed?
Yes, everything's, well, not everything. So Judge Gibson denied a motion to dismiss. There are two grounds essentially that they've appealed. One is their argument that this is a political question and that partisan gerrymandering is non-justiciable. And then non-justiciable for you non-lawyers just means the courts don't have any way to adjudicate it. The reason that the federal courts have gotten out of that since there's a case called Rucho that was back in 2017, is they held that there were no judicially manageable standards to determine whether partisan maps violated the Constitution. They have conceded that what's called malapportionment, which is different numbers of people in different districts, or racial gerrymandering, can be challenged in court. So it's a little curious as to what the argument is, because if the legislature just had unfettered, unchecked power to draw lines with no role of the courts, it seems odd to be creating exceptions that aren't also in that language. But they've made that concession. And also, by the way, I mean, the maps are subject to gubernatorial veto, which is also inconsistent with the idea that the courts have no role. So that's the first argument. And the second one they've appealed is just a determination on the merits. They had argued that we hadn't stated, even if courts could review it, we hadn't stated a claim for these particular constitutional violations based on the meaning of these provisions. And she rejected all of those arguments as well and held that each of our claims stated a claim. In her ruling, she dismissed our claim that said that the repeal of Prop 4 was unconstitutional. And basically her ruling was the people can pass legislation and the legislature can repeal that legislation, and there's not really anything that the citizens can do about that. And you know, that was a close call. We always knew, and we have appealed sort of a cross appeal, but it's a little bit procedurally different because it's interlocked. But so that is also up on appeal, and so we will be making the argument that the court erred when it dismissed that claim, and they'll be making the argument that the court erred when it didn't dismiss our other claims.
Thanks.
Well, man, I must have either been really boring or I gave you all the information you needed. So I'm happy to turn the time over to Katie if there's nothing else. And I'll stick on for the next little bit. So if questions do come up, just stick up your hands.
That would be good. I think the issue is it's just a hard thing to understand.
Yeah.
all right. Well, thank you for having me and David today. I think a lot of you know a lot about Better Boundaries, but just as a quick kind of overview, our purpose is really to serve as Utah's anti-gerrymandering advocacy organization. And at the heart of it all, we truly believe that voters should be making the choices when they cast their ballot versus politicians picking their voters. And I will just tell you an anecdote that one of my team members, Kyle, attends a lot of the Republican caucuses and conventions and things. And he heard a little bit up north, maybe it was Cache Valley, one of the folks who got on the stage and said to the town, I chose you, I wanted you, I picked you. And so it's pretty brazen out there, this flip-flop of how democracy should work. And he meant it, of course, as a compliment. So the process of, we've been at this for a while, and we couldn't be at it without such great partners like the League, because I know you've been at anti-gerrymandering even longer. But here's a little timeline of how we've done our work. In 2017, we established our organization. And then 2018, we got on the ballot and then successfully passed the initiative, which is no small feat. Initiatives are very difficult to get on the ballot and very difficult to pass, and only getting harder, which I'll get into a little bit later. But then in 2020, as David has talked about, the legislature repealed that citizen initiative and ultimately passed a much more watered down version. In 2021, we went through the redistricting process, just like states across America following the census. And what we saw there was a really excellent job by the independent commission to follow standards that put voters first, and also to have an extremely transparent process that took citizen and community input and used it in the drawing of the maps. They were absolutely stellar. They put partisanship aside, and they really, worked together, except for in one example, really across all partisan considerations. However, politics reigned the day, and the legislature also ultimately adopted maps at the congressional and state house and senate that really entrenched politicians in their seats and made it impossible for communities to elect someone that they wanted. Really sliced and diced and cracked Democrats, but also I will say in the Senate and House, just made it both on the Republican and Democrat side. So we have a lot of safe seats that aren't competitive. So in 2022, we joined with the plaintiffs, and our role in the lawsuit is to continue to advocate and engage Utahns across the country in this issue, but also to pay the financial cost of the lawsuit. And I want to pause there and just say that David Ryman's firm and also Zimmerman Brewer, our Utah firms, are offering all of their deep expertise at a low bono rate, and we are incredibly grateful. And Campaign Legal Center is doing this pro bono. So the actual cost for the case is significantly reduced by those donations, and we're very, very grateful for that. I had this opportunity to speak to a University of Utah class, which was all exchange students, mostly from China and Taiwan and Asia. And I kind of got back to the basics in that presentation of like, what is gerrymandering? And I thought I'd bring it up today because it really is manipulating these lines. And one thing that I think about a lot and why this has become such an issue now, and David touched on this a little bit, is that this has happened since the beginning of our nation. But in the era of big data, where literally they know that we're all thinking about buying a new snow shovel because ours are worn out and broken, and that that snow shovels are being advertised to us as we like read our new online newspaper, and like big data knows us better than we know ourselves. And that's why partisan this gerrymandering can be so precise to literally lock in elections for the next decade. And it's gone from a problem to an extreme problem. And that's why we're seeing cases across the country. And I'll add that this era of big data is also the solution to gerrymandering, because we now have ways mathematically to show how extreme it is and say, this isn't just some politics on the side, a little wrangling about one neighborhood or the other. This is a precision job to really get rid of the influence of voting and accountability. And because of big data, we can show that in the court. Now, unfortunately, we haven't had the opportunity yet because of all these delay tactics. When ultimately, optimistically, I feel that it will go to trial, we will see just how extreme and just how precise it has been. So why is gerrymandering bad? Well, since we're talking to Summit County today, we all know why it's bad. I mean, look at this legislative session. We have no representation in our community at all on the Hill, which means all of us taxpayers are footing the bill for lobbyists to run around talking about what's interesting and important to our community in our own state. I mean, we have a very particular economy here, and no one is representing us, not one. We are completely sliced and diced. And so I know that across the state, January, February ends up being a pretty stressful time for a lot of Utahns when the legislature is doing its business, but especially up here in Summit County, when we literally have no one representing us, it just becomes so clear how gerrymandering is bad. It's just bad. So I just want to say, because this group knows that the complaint, when I read it, I sort of cried, because everything that individuals have done, individuals like your organization has done, is written into the complaint to show just how hard we have worked to reform our government to get a fairer process, and just how far our legislature has gone to consolidate power and take it away from the voters. So I just want you to know that although we are still in this fight and it is not yet over, all of those actions really are consequential and important to the process. And with that, I'm happy to answer more questions about the case. Or I had talked to Jill that there's a few bills that we're watching at Better Boundary that I'm also happy to get into as you wish. But that's sort of the end of my slideshow about the lawsuit in particular.
I'm at a loss right now. Katie, what did you just ask? What
Sure.
did you want to do?
One of two things. One, I'm either happy to take any questions now, if there's any further questions about the lawsuit, or if it's interesting to folks, I could talk about some of the bills that we're watching in the legislature. So happy to do either.
First of all, I think David is off now, right?
I think he is, yes.
Okay. So glad that you had him on, though. Okay, Katie, about the lawsuit, is there anything that we as the League of Women Voters should be doing, or how to follow it?
Yes. Well, in terms of following it, we are trying to provide regular updates via our email and email newsletter and social media. And also, some written reports and things. We have the webinar on the 10th, which will be a good update as well, although I don't know if we'll know anything more than what we've shared today at that point. In terms of how to activate, I do think it's very important that as we're talking to our elected officials, we remind them that this is important, and that as we look at issues that are impacting us, we draw the line explicitly back to gerrymandering. So whatever you think about some of the conversations around developments here in Summit County, the fact that the state government is taking the control from our local government in so many of these developments, cherry picking, rules and sticking them into bills, that's a real power grab. And it's something that comes back to gerrymandering, the fact that we don't actually have representation for us on the Hill. And so I think it's important to not only look at the bills that are on issues that matter to you personally, but also remember back and remind the elected officials that we know that this is a result of gerrymandering.
Okay.
And I think that matters in letters to the editor and things as well.
Right. Yeah, I do write emails to my senator, state senator, and representative who lives in Heber or Midway. Does Kohler live in Midway or Heber? Midway? Okay. Anyway, I'd never thought about inserting a gerrymandering reminder. That's a great idea.
Yeah, I mean, they might not want to hear it, but
Terry Goodall. Terry, can
Yes, yes.
you?
Yeah, I can.
Okay.
I can hear you. Yes.
Okay. We have Wasatch people on this call too.
yes, I'm sorry. I
Yes,
forgot
Connie.
I am Wasatch. I didn't mean to leave you out,
No,
Wasatch.
I mean, no, that's okay. I mean, we rely on the voters in Summit County to help us in our House district. And since the gerrymandered district became more one-sided than it already was, yeah, we're real interested in what's going on in this case because it has some impact for us. I mean, at one point we thought we could flip a seat and now it's looking unlikely.
And that story is unfortunately consistent with other districts across the state,
Right.
where races were close. And what we have seen, and again, we're a nonpartisan organization just like yours, but every state has its imbalance. And what we've seen is that as the decade progresses, Democrats gain seats, and then we redistrict and we fall back. And one, pretty seasoned political lobbyist said to me, well, actually, I was pleasantly surprised. We did okay considering it was a redistrict, this past election was a post-redistricting election. So it's an unfortunate cycle.
Katie, Better Boundaries has a PAC, right?
Mm-hmm.
And it seems like you supported 13 candidates for the state Senate who would be open and aware about gerrymandering. Did those 13 people get elected?
No, we did not win all of the races. We had a few moderate Republicans that we supported in primaries who did not make it all the way through, which is unfortunate. But something that we are going to continue on is to really work to elect folks that put as one of their top values accountable government and transparent practices. The lawsuit is focused on the congressional, but as we've discussed, the House and Senate maps are also really bad. And I will tell you that we had politicians from both sides of the aisle who were behind closed doors drawing maps that favored themselves. And so it is really critical that we make explicit that we have folks who know that we helped them get elected based on a value of voter-centered standards. So it is a long game to try to vote, get these people elected. And but gerrymandering is really hard. There's no easy solutions. So we're going to try many different tactics, and that the PAC is one of them.
I'm glad to hear that. I thought it might be a conflict of interest for Better Boundaries to actually support candidates, but I'm glad to know that they're being supported across the aisle, so the people know it's not just Better Boundaries is not just there to increase the Democratic contingency, even though that's what I think we all here in this room would like to have. But is that being well publicized that you're supporting both sides?
Yes. Yeah, because we gave we have a report card, and we scored Democrats who did badly. And, I've received pushback for that, but I mean that you have to earn the grade you get. That's not my problem. That's their bad vote. So I do think that there has been notice about that. Good. But we will always, the nature of working in a state that is a supermajority is that, of course, if we are successful, one party will lose a little bit of power and the other one will gain a little power. But that's actually not our focus. Our focus is voters. What power do we, the voters, take back? But there will always be suspicions that we're working for one side or the other, but we do try to counter that and make it very explicit.
Thank you very much.
Is that a scorecard on your website, Katie?
It is. Mm-hmm.
Okay.
It is from early 2022 post-adoption. So
what would that be under? How would
I think if you go to I can provide the link. Hold on. And I also see that Helen has her hand raised, so I am happy to.
Yeah, sure. And Katie, this might have been a better question for David, but he seemed to be kind of guardedly optimistic about the outcome from the Utah Supreme Court. But so based on the current composition, so this may be, again, better directed to him, but based on what you see in terms of the current composition of the court and their previous rulings, is there any aspect that kind of comes through that should give us optimism that will prevail and to get a favorable ruling?
Well, if I could channel the lawyers, what I would say is that he used the term tea leaves, and it does feel that way. So we have a number. There have been 3 new justices appointed in the past, I think, 2.5 years. And so the makeup and culture of the court has likely changed fairly dramatically, and we don't yet know how they will rule. And in particular, Justice Lee stepped down, and he just had a very, from what I've heard and how people talk about it, he was an automatic no vote. I mean, there's, he's like an constitution, you take the Constitution, anyway, I'm not going to try to get into his head, but he was an automatic no vote. But on top of that, he wielded a lot of power on the culture of the court. So that's what I hear from the attorneys. This is not, I'm no expert in that. Maybe Linda, I see you raising your hand. Maybe you have a thought about that.
Yeah, I would say that what the state is arguing is very extreme. To argue that the courts have no role at all in overseeing elections, and that's based on a theory of the legislative primacy, which is a really out there extreme theory that's being argued to the Supreme Court, U.S. Supreme Court, this term. But part of it is picking up on that sort of extreme argument. So the non-justiciable argument, David was pointing out how it didn't make internal sense if it could be vetoed by the governor and so on. How could you say that it's only to the legislature? And the theory that the legislature has all power because the legislature has the authority to govern elections, that's just way out there. So he would feel optimistic because their argument is so extreme. And then the second argument that there's no claim stated here in this case. I mean, that's a throwaway argument that lawyers make in every case. You always, move to dismiss for failure to state a claim upon which relief can be granted, and that's like never wins. So, I would imagine that they feel that the state's arguments are so extreme, and it's a little weird that the Supreme Court chose to take an interlocutory appeal, because generally the court wants there to be a trial and then a complete record and then comes forward. Maybe that was just extreme honor and respect to the legislature that they took the appeal. It just delays things from our perspective, because we don't get a trial. We can't win at this point, right? We can only not lose. So it's frustrating to have had the Supreme Court take the appeal, but maybe they wanted to do that just to be extra respectful to the legislature. A little bit like taking an interlocutory appeal in the abortion case too. It's like, what's with all these interlocutory appeals? Mm-hmm. You're supposed to have a trial and then have an appeal. Mm-hmm. They're newer justices, and maybe they're feeling they shouldn't, punch the legislature in the nose, and by letting them do an appeal, they're giving them some honor. I'd say it's an interesting claim that the trial judge dismissed the Proposition 4 claim. That's not been litigated much. I don't know how it's been litigated in other states, but I think the trial judge makes sense from the perspective of, if you passed a proposition and then years passed and circumstances changed, you certainly can't say the legislature can never change the law. That would be insane. But here, years didn't pass, circumstances didn't change. They immediately basically overturned the proposition. And that's a little extreme. So I'm glad we're doing a cross appeal. Maybe that will get reinstated. As long as we're going to have a trial, you might as well have a trial on everything.
I appreciate your thoughts on that, on the Supreme Court. I think that is all really, really good insight. And the only thing I'll add that I've heard again from the attorneys is that their discretionary docket of cases that they don't have to take, but they have, is quite full. So we're not alone in that. And I think that, so again, but it's just like reading into these things that are hard to read into. And also, I agree that the repeal of Prop 4 is based around this idea that we have an explicit right to reform our government. And I think there is an argument of like, how do we practically exercise that right now? It's being fought right now, in the legislature, which I did get a question from either my mom and dad. I can't tell who's on because they don't have their, but saying, is there a bill that would make it more difficult to get initiatives on the ballot? It's a lot has been done between 2018 and now to make it much harder to get on the ballot. The bill that is, it's a joint bill, HB 422, HJR 17. It would eventually have to go to a vote for an amendment. It's about actually getting a bill or a ballot passed. So what it's doing is saying that if the ballot initiative has a fiscal impact, then you have to get 60% of the vote, which is extremely difficult. Because as I said before, when people go in to vote, their knee-jerk, like off-the-cuff response to ballot initiatives is no. And you have to educate people into voting yes. So they're very hard to pass. And so to take it up to a 60% threshold is extremely challenging, and just one more way that, in my view, the legislature is taking that power of initiatives from the people and just making it impossible and consolidating it. So we are at Better Boundaries actively opposing that bill. I think it will be in a taxation meeting later today, but as I said earlier, I feel like some agendas got revised, so I kind of lost some of my thread on when things are being heard. But we are actively opposing that, and it's being framed as a taxation, a taxation situation. So it is being well received in the legislature.
The League of Women Voters is opposing that bill too.
Excellent.
So that bill would, if it passed, then there would be on the ballot in the next election.
In 2024.
23-24. The question, should we change our constitution to 60% threshold? Am I right?
Mm-hmm. For ballot initiatives that have a tax implication. So it would be hard to counter it. First of all, you would have to raise a lot of money to do a marketing and education campaign. And then also just with the framing of it being a taxation bill, it will be challenging to beat it.
Right. That does not sound good. More questions? I wanted to go back to something. I'm still really confused about, and maybe Linda Smith can help on this too. You mentioned an interlocutory appeal and then a cross appeal. Those sound like intermediate stages. Will there be a trial?
We hope so, but the Utah Supreme Court needs to rule in favor of the plaintiffs. Am I right, Linda? I mean,
yeah, if the Supreme Court buys the state's argument that the courts have no role in overseeing gerrymandering, or that there is no case here at all, then the state will win and there won't be a trial and it will be over. But if we win and the Supreme Court says, yep, courts do have a role in overseeing gerrymandering, and yep, there is a case here to be argued, then it'll go back for a trial.
Okay, before the Utah Supreme Court.
No, the trial is before the district court, right?
Okay.
Individual judges try cases and then they issue a decision. And what happened here was Diana Gibson heard a motion, which is a temporary request, a request for temporary relief. And the motion was the state's motion to dismiss the case, right? Let's not get evidence. Let's not, have discovery. Let's not have a trial. Just kick the case out because there's no case here, just on the papers. And if the Supreme Court says, yeah, kick the case out, there's no case here, then there won't be a trial. But if the Supreme Court says, no, what these people, the plaintiffs have said is something that can be argued, then we'll have a trial and people will, there'll be evidence about the degree of gerrymandering and how it was done and how it didn't need to be done and how the commission did a really good job and any one of those maps would have been just fine and wouldn't have, eliminated many voters' rights. And then the trial court will make a decision and they'll decide, we win or we lose. And then there'll be another appeal.
So the trial court will be a district court.
Yeah.
And do we know whose court that would be in?
Well, it's Diana Gibson's case. So unless she dies or resigns, it'll be her case.
Okay.
Unless there's, some reason to kick her off the case, and nobody's made any complaints about her at this point. So, and then after she hears the trial, which hopefully, that's why David was saying, hopefully we'll get a decision from the Supreme Court this fall. So there could be a trial in the spring or in the summer. So we could get a decision before the next election. I mean, it's looking really difficult to do that. A decision before the next gerrymandering opportunity in 2030.
Yeah, you really, I mean, ideally for the 2024 election, ideally you would have a decision before the end of this year, because candidates have the right to gather signatures, and that's sort of what kicks off the timeline. Now, but candidate timelines can be changed, and there's precedent for that, in other states.
But they might not have gone through all of the information by end of 2023 this year, right?
Yeah, the timeline is very challenging in terms of having this resolved for the 2024 election, but it is not impossible.
Okay. Okay, more questions? Back to candidates who recognize gerrymandering and the 13 that you work to get on elected. You're going to want to do that again for the 2024 election, right?
Yes.
Okay. So you are nonpartisan, and the League of Women Voters is nonpartisan.
Mm-hmm.
How can we be helpful?
Well, that's an interesting question. Certainly, on an individual basis, we will be asking people to support the PAC or specific candidates, but also to volunteer. It's so important to have people knocking doors on behalf of candidates, and that's something that we'll rally around. So what we tried to do was not only give financial support to the people we were, supporting or endorsing, but also provide, some expertise in terms of best practices in running good campaigns, but also boots on the ground in terms of volunteer. So if that is something that you're interested in, just look for our emails surrounding our PAC, and that's a way people can support that. But on a much more individual level, I think just as you go about to candidate forums and debates, asking questions about gerrymandering and good governance, I think is something we just need to remember to do to keep this issue that it's challenging, it only being once a decade, on the minds of our elected officials, that we do care that that our government acts in a transparent way and removes conflict of interests. And I think that's really important.
Well, you are doing a good job right now of getting it back in front of people's minds, and thank you for that.
Happy to. I thought I would just mention two other bills that we're watching with just like a couple minutes left, if there's time. Okay, I'll be quick. Yes. There was one called HB 537. It's from Representative Brooklyn, who does represent some of Summit County. I don't think she goes into Wasatch County, but the idea would be to get rid of vote by mail as a default. At 93% of Utahns voted by mail in this past election, despite people's concerns about election security. It is wildly popular. The lieutenant governor has come out against this bill. She opposes it. Her office opposes it, I should say. We think that it might be dead in the water. It was sent from committee back to rules, so that's not a good sign. But I do think keeping our eye on it is important, because vote by mail is just such a positive reform for voter access. The other bill that we are watching closely is HB 393. Some of you are probably familiar with Count My Vote. SB 54 was a piece of legislation that creates two paths to get on the ballot. You can go through the caucus convention, or you can gather signatures to get on the primary ballot for your party. In this case, if someone won at caucus convention at 70%, then it would throw out all the candidates who gathered signatures, and that person would become the party's nomination. So what it does is it eliminates that two-pronged process for people who get a certain threshold. Why we think that is bad is that, again, it eliminates voter choice, and it puts the decision into the hands of delegates. And delegates are, one, just a small group of people. So you have essentially a small group of people electing folks, because people don't necessarily have opponents in the general election and things like that. And also it creates just more extremism. And we just appreciate any opportunity for voters to have choice. And so this eliminates choice. I think that is headed to the Senate Committee for Government and Operations. It did pass the House floor on Friday. So we're watching that one as well.
I don't know if the League of Women Voters has a position on that bill,
I don't know either. I'm not sure.
but I would think that the vote by mail, they would. We would,
Mm-hmm.
but I hope that one is dead. Okay, any other questions? We have about 2 minutes. Well, the League of Women Voters and Better Boundaries has worked hand in hand since you began 2017, and just keep us informed, keep us involved. We want to be. Any other advice from anybody still on the call? We want to help. We want to be on the right side of history here. Thank you, Katie, very much.
Thank you for having me. I really appreciate it, and I really appreciate our partnership.